It is 6 o'clock in the morning. Your phone vibrates on the nightstand. You check your email half awake and your stomach sinks. The subject line reads, "Important notice regarding your case." Your hands are already trembling before you even tap it open. You think about your children still asleep in the next room. You think about the years you waited, the paperwork you completed, the legal fees you paid, the interview you practiced for so carefully. And now, there is a new USCIS rule, and no one around you seems to understand exactly what it means. Your cousin says one thing. A stranger on TikTok says something different. Your neighbour insists her friend was denied because of this exact rule. And you are sitting there, alone, with your coffee turning cold, wondering if everything you've built in this country is about to unravel because of one document you do not fully understand. If this feels familiar, pause and take a breath right now. What I am about to explain is not panic. It is not rumour. It is not second-hand information. It is the actual legal framework behind this new USCIS rule, explained in clear language so you know precisely what step to take next. Stay with me until the end, because the final section of this video is the part most people overlook, and it is the part that protects you the most. Here is why so many people misunderstand situations like this. When USCIS releases a new rule or policy memo, there is often a period of confusion lasting days or even weeks. During that time, three things tend to happen simultaneously. First, the official guidance is written in complex legal language that is difficult for most people to interpret quickly. Second, social media fills the silence with speculation, partial screenshots, and confident voices who have never actually handled a case before an immigration officer. Third, and most risky, individuals who are not licensed attorneys, sometimes called notarios in certain communities, begin offering guaranteed advice for a fee, even though they are not authorized to represent you and are not accountable if their guidance harms your case. This combination creates what I call a system trap. Not because USCIS is deliberately trying to mislead you, but because the structure of the system can penalize confusion. A missed deadline buried deep in a memo. An interview question that sounds simple but tests whether you understand your case timeline. Advice telling you to do nothing when inaction is exactly what creates harm. Most people who encounter problems under a new rule are not dishonest and did not misrepresent anything. They relied on the wrong source, or froze instead of taking organised action. By the time they recognised the issue, the window to respond had already closed. Let us slow down and focus on what actually protects you. Under the Immigration and Nationality Act, often called the INA, individuals inside the United States have rights that do not disappear because of a new policy memo. This includes due process protections under the Fifth Amendment, meaning the government cannot remove your status or detain you without providing a fair opportunity to respond. It also includes protections under the Fourth Amendment, meaning officers generally cannot enter your home without your consent or a judicial warrant signed by a judge. Not every document presented by an officer is a judicial warrant. You have the right to ask to see it and confirm whether it carries a judge's signature before opening your door. New USCIS rules typically include an effective date and often a transition provision for cases filed before that date. This detail is frequently misunderstood. People assume a new policy automatically applies retroactively to erase pending cases. In many instances, USCIS explicitly explains how pending filings are treated differently from new submissions made after the effective date. Your filing date compared to the policy's effective date is often the key detail separating unnecessary panic from calm confirmation that your case remains unaffected. Social media often gets this wrong. Some videos claim that a new rule means automatic deportation for anyone with a pending application. That is rarely how policy works. A USCIS memo guides how officers apply existing law. It does not override the INA and cannot eliminate constitutional due process rights. Other advice online tells people to ignore USCIS letters because they might be fake or simply meant to intimidate. Ignoring official mail is extremely risky. Even if language is confusing, failing to respond can cause real deadlines to pass. The correct approach is to read the notice carefully, confirm the case number and date against your records, and verify anything unclear directly through your USCIS account or with a licensed immigration attorney. There are also rumours about so-called instant denials. In most categories, USCIS policy still involves issuing a request for evidence or a notice of intent to deny before a final decision, giving applicants an opportunity to respond. There are limited exceptions, which is why broad advice from social media can be dangerous. Your visa category, filing date, and facts matter. Now let us focus on your action plan. Imagine working through this checklist calmly tonight. Step 1. Retrieve your I-94 and your most recent USCIS notice. The I-94 record shows your authorized period of stay and can be accessed through the official CBP website. Compare the expiration date with today's date. This establishes whether you remain within authorized status. Step 2. Log into your USCIS account directly through uscis.gov. Do not use links sent by text message. Review your case status and history carefully. Write down any deadline listed in official notices. If something is unclear, that uncertainty signals it is time to seek professional guidance rather than guess. Step 3. Organize supporting documents now. Gather IRS, tax transcripts, employment letters, proof of address, and copies of every form submitted. Many new policies emphasize consistency in address, employment, and tax history. Organization prevents last-minute stress. Step 4. If you have legal representation, ask a specific question. Based on my filing date and category, does this policy memo apply to me, and what is my response deadline? Specific questions produce useful answers. Step 5. If an officer contacts you and you do not understand the question, calmly ask for clarification. During interviews, you may request repetition or indicate you wish to consult counsel before responding. Clear communication protects you. Step 6. Rely only on official sources. Review updates directly from uscis.gov or the Federal Register. Policy text is publicly available. Be cautious of anyone charging money simply to read you information that is freely accessible. This method works because most immigration mistakes stem from missed deadlines, inconsistent documentation, or panic responses. Checking your status early gives you more options, not fewer. A case with 90 days remaining and organized documents is in a stronger position than one with 10 days left and no preparation. If cost is a concern, non-profit legal aid organizations and Department of Justice accredited representatives may offer low-cost assistance. Verify credentials before accepting guidance. New USCIS memos usually clarify internal procedures, documentation standards, or processing priorities. They do not eliminate constitutional protections. Procedures can shift. Core legal rights remain stable. If you are watching this late at night after work, seeking clarity instead of guessing already places you ahead. Confusion causes more harm than most policy updates themselves. This platform exists to translate complex immigration developments into clear steps you can follow. Staying informed through official channels and preparing early gives you control over what you can control. Before you finish this video, complete the 6 steps we discussed. Pull your I-94. Check your official case status. Organize your documents. Prepare a specific question for qualified legal counsel. Practice calm, clear responses. Follow only verified sources for updates. You do not need to be an attorney to protect yourself. You need organization and reliable information. Stay informed, protect your status, protect your family.